In the previous lecture we discussed about warrant of arrest. We also learned that warrant of arrest is one of the mode to secure the presence of the accused. But arresting a person is not always so easy. It is a very common tendency of any person to escape and conceal himself in order to avoid his arrest. After all, no one wants to get arrested, right? Our legislators are also anticipated this, and in order to force the accused to surrender before the court, included Section 82 under the Criminal Procedure Code. Section 82 deals with publication of proclamation. Proclamation means some public announcement or public declaration. Section 82 says, if the court has reasons to believe that a person, against whom warrant of arrest has been issued, is absconding or concealing himself, to avoid his arrest, then the court may publish a written proclamation, requiring him to appear within 30 days from the issue of such proclamation, at the specified time and place mentioned in the proclamation. So, a proclamation can be issued if two conditions are satisfied. First, a court has issued warrant of arrest against a person, and second, such person absconds or conceals himself in order to avoid his arrest. It is not necessary that a person should run from his house in order to be called an absconder. It is enough if he hides himself within his house to avoid his arrest. If these two conditions are satisfied, the court has the power to issue proclamation under Section 82. It is important to note that the court cannot issue the warrant of arrest and proclamation simultaneously. Proclamation is a measure taken by the court only after it is unable to secure the presence of the accused through the warrant of arrest. Now, how is a proclamation published? There are two ways to publish a proclamation. The first way has 3 steps. First step is by reading it publicly at some conspicuous place of town or village, where the absconding person usually resides. It basically means making a public announcement through words of mouth. But only reading out the proclamation is not enough. There is step number 2 to be followed. Under step number 2, the written proclamation must be affixed at some conspicuous part of the house in which such absconder ordinarily resides. And the third and final step is to also affix the copy of proclamation at some conspicuous part of the courthouse. When all the 3 steps are complete, the proclamation can be said to be validly issued. If any of the step is not complete, the proclamation will deem to be not complete, and will be null and void. The second way of issuing proclamation is by publishing the proclamation in a local daily newspaper, where such absconder ordinarily resides. Take a look at the proclamation issued in a newspaper as an example. When the proclamation is published as per any of the above 2 ways, the court issuing the proclamation is notified accordingly. The court then issues a written statement, stating that the proclamation has been duly published on a specified date, and in a specified manner. This statement of the court will be the conclusive evidence about proper publication of the proclamation. By conclusive evidence it means that now no one can provide any other evidence to prove that the proclamation was not validly issued. However, issuance of a valid publication cannot be treated as an evidence of the validity of warrant of arrest. Once the person is arrested, the proclamation ceases to be in effect. It is not like if a proclamation is issued by a court, a person will be called an absconder all his life. Now, a very important question. What is the objective of issuing a proclamation? When the person is already absconding or concealing himself to avoid his arrest. When the person is already evading the warrant of arrest, why will the person appear before the court after issuance of proclamation? What difference does it make? Well, the issuance of proclamation does make a difference for two reasons. First, the disobedience of proclamation is punishable under Section 174 of the Indian Penal Code. Second and most important reasons is that, after issuance of the proclamation, CRPC empowers the court to attach the property of the accused. Attachment of property is a harsh measure, but it intended to secure the presence of the absconder, rather than to punish him. Let's learn more about attachment of property. As per Section 83, once the court has issued a proclamation, the court is then empowered to order attachment of the property of the absconder. Attachment of property means to seize the property. Let's look at some important points with respect to attachment of property. The order of attachment is generally issued after the proclamation is issued. However, the court can also pass an order of attachment simultaneously with the issuance of proclamation in two situations. If the court is satisfied that the person against whom proclamation is to be issued is about to dispose of whole or any part of his property, or is about to remove it from the local jurisdiction of the court can order attachment of property simultaneously with issuance of proclamation. Now, what type of property can be attached? Under CRPC, the court is empowered to attach both movable and immovable property. Now, what is the mode of attachment of movable property? A movable property can be attached either by any one or all of the following modes. First, by seizure. That means simply taking over the possession of the property by the order of the court, or second, the court may appoint receiver. Receiver means a person who is authorized to receive sale proceeds from the sale of the property, or receive rent if the property is leased. Third, if the absconder has purchased some movable property but it is not delivered to him, then the court can prohibit delivery of such property to the absconder. For example, if the absconder has booked a car but it is not yet delivered to him, then the court can prohibit the car company from delivering the car to him. Similarly, if the absconder receives any rent from any of his movable property, the court can prohibit payment of such rent to him or anyone on his behalf. Now, let's look at the mode of attachment of immovable property. An immovable property can be attached in the following ways. First, if the immovable property to be attached is a land, paying revenue to the state gov, then such land can be attached through the collector of the district. In any other case, the immovable property can be attached by 1. By simply taking the possession of the immovable property, or 2. By prohibiting the payment of rent or delivery of the immovable property. Now, sometimes it may so happen that a person other than the absconder may have an interest in the property attached. In such cases, such person may raise an objection within 6 months to the court on the ground that he has an interest in the property, and that the property should not be attached. The claim or objection of such person will be inquired into by the court, and based on such inquiry the court may partly or wholly allow or disallow the claim or objection. Where the claim or objection is disallowed, whether wholly or partly, the person gets a right to file a civil suit within 1 year to establish his right over the property. The final order made by the court after inquiry is conclusive subject to the decision of the civil court, in case a civil suit is filed within 1 year. Let's now discuss about restoration of property. Once a person against whom proclamation is issued appears before the court within the time mentioned in the proclamation, the attachment of the property will be withdrawn, because attachment is only a measure to compel the appearance of a person, and not to punish him. However, if the person does not appear before the court within the stated time in the proclamation, the property shall remain attached with the state government. It is important to note that the property cannot be sold off until 6 months have passed from the date of attachment or date of claim or objection made, as the case may be. However, in case the property is livestock, or anything of perishable nature, the court can order its immediate sale to prevent such goods from spoiling, provided the sale is beneficial to its owner. Sale proceeds from such sale will be used as per the order of the court. Section 85. Subsection 3 further says that if the person against whom proclamation is issued appears within 2 years from the date of attachment of property, and such person proves to the satisfaction of the court that he was not absconding or concealing himself to avoid his arrest, but he had no notice of such proclamation, then the court may order restoration of the property. Or where the property was sold, the court may order payment of the net proceeds from the sale after deducting expenses to such proclaimed person. If a court refused to restore the property, the proclaimed person has a right to appeal against such order of the court. Alright. So, this was all about proclamation and attachment of property. If you liked this information, subscribe to the YouTube channel Legal Ontologies to get associated with us.